I now request Advocate Vyankat Bedre sir to kindly felicitate Honorable Judge K.K. Zadhav. It is my proud privilege to introduce a distinguished judicial officer whose journey reflects dedication, scholarship, and an unwavering commitment to the administration of justice. Honorable Shri Rahul Bhosle sir, presently serving as District Judge 1 at Latur, is a respected name in judicial fraternity, known for his integrity, academic excellence, and vast judicial experience. An alumnus of the prestigious University of Law, he is a silver medalist in Masters of Law, a testament to his strong academic foundation and deep understanding of legal principles. During his distinguished judicial career, he has handled several complex matters and has served as a special judge for important central and special statutes, including cases investigated by Central Bureau of Investigation, matters under the Maharashtra Protection of Depositors Act, the National Investigation Agency, the Unlawful Activities Prevention Act, the Maharashtra Control of Organized Crime Act, and the Terrorist and Disruptive Activities Act at Mumbai. His association with such specialized courts reflect the immense trust repose in him in dealing with matters of national importance and public interest. Before joining the judicial services, he has contributed to legal education as an associate professor at Nagpur.
Madam, sorry to disturb you. Let the entire quorum should recognize me from my speech only. So already we are running. I think we are running 1 hour past. So straightway I will start. Are you going to permit me to start? Okay. I am Rahul Bhosle, presently working as a District Judge 1 at Latur District Court. Today, we have done your job also in Lok Adalat. We have disposed of appropriate number of matters. So your clients would not be aggrieved upon you. We have taken already care of you. Now, when the program is arranged by advocates, I was in fact apprehended this scene because this scene happens here, but I face this scene in court hall day to day, day in, day out. Because whenever the advocate is called, he would not promptly respond. He would only come before the court after doing his other work, instructions to the clients or engagement in other court. So we are used to wait for lawyers for 1 hour, 1.5 hours, and this is today also is not an exception for that. Okay, with that note, I will start. In fact, I will not give the PowerPoint presentation, though the subject is in respect of electronic evidence. Because what I think that I'm not, in fact, expert in this field. Because when Honorable President of Latur Bar has invited me by giving invitation card, I read some big words on it, Advocates Conclave. I was little bit comfortable with that. Advocates Conclave means the meeting arranged by the private persons is conclave. But I stumbled myself when I go through the word symposium. So when I Googled, as usual, like you also, I Googled what is symposium. So symposium is a meeting wherein an expert have discussions on special topic. I failed to understand who is expert then. If I am called here, who is expert? But I thought I gave deliberation on that topic. And one ray of hope came into my mind as I recalled the judgments of Honorable Apex Court, wherein it has been held that advocates are experts in law. And they are teaching you the law. Thereafter, I realized that I am called here to discuss with you experts in symposium. That is why I am here. It is expected that if I am wrong on any concept, you are at liberty to raise an objection by standing, because generally you don't have such powers in court hall. So I am expecting that experts should intervene whenever I will be at wrong side. As the student of law, we all know the difference in between information and knowledge. Information, you may know that the various social sites, internet, Googling, you can earn tons of information. And now in this era of information and technology, you know that fourth revolution is of computers and fifth revolution of AI, artificial intelligence. So this is the era of information and technology. The information is poured on you. Then if that information is easily available in market, then why we are here? I tried to find out answer to this thinking that information, when you take in your mind, that is input, your brain having thousands of petabyte memory, you can easily say 10,000 iPhone's memory our brain has. So our brain transform that information into certain patches of memory by shuffling the irrelevant data. So that stored memory is called as knowledge, and knowledge is output. After standing as a judicial officer for 25 years, what I earned from you all in court hall will be my knowledge, and I am here today to share my knowledge to you. It is my gratitude towards you that what I earned from you, I will try little bit to give you back. I remember one quote of Honorable Justice Bhatia, then senior judge. He once said that if you realize that in particular station, if you are writing judgments very good, then it presupposes that the bar there is teaching you the good law. And that's why you are writing good judgments. And since coming at Latur, for last 8 months, I think I am writing good judgments. That is because of the contribution of Latur bar, of course. So now it is my turn to give something back to you. That's why I am here. I am not giving you any information. I'm here giving you certain sort of knowledge. And before proceeding further, I would like to quote the father of modern jurisprudence, Jeremy Bentham, that once he said that you being a law student enters into the legal field, then you are become student for life. And what is the basic characteristic of student? you all know that student means to study only. The person who studies is student. Likewise, आपले जगद्गुरू तुकाराम महाराज यावरती असं म्हणालेत, असाध्य ते साध्य करिता सायस कारण अभ्यास तुका म्हणे. तुकाराम महाराज पण म्हणतात की आपण अभ्यास केला पाहिजे. Jeremy Bentham also says that you being student, you have to study. See, the great luminaries, great viewers having same opinion. So it is now up to us to study hard to get through our profession. In fact, we are having certain talks with the senior lawyers before entering into the hall that nowadays the legal fraternity, including us also, turning towards not obeying the rules of profession. So what would be the professional rules? Certainly they are different from business rules. Business would only see profit. Profession would bring the professional ethics in what the duty we are doing. So let us go directly towards our subject. Today's subject is electronic evidence. So once you decided that we have to study the subject from its root, obviously we have to study the words also, electronic evidence. Why electronic? You all know that electronics is the branch of applied physics. We study the characteristic of electron. Electron, you all know that every atom of every state consists three particles. One is proton, which is positively charged. Another is neutron, which is not having any charge. Electron. Electron is negatively charged particle of the atom. So why electron is here? Electron is having very good capacity to travel through any medium, conductor medium, semiconductor medium. When the electron runs through conductor medium, it becomes electricity. When electron runs in restricted conductor, means semiconductor, Faraday's tube you know, vacuum tubes you know, so it can be easily controlled. Having speed, easily controlled, and it has very much capacity to store 10 times information than its weight. So that's why electron is used in certain gadgets by using transistors, chips. If you see mobile phone or computer, if opened, CPU is opened, you would see the transistors, chip-like structures. So they are basically the imbibed electrons into evacuated space. So I will simplify because I am not an expert in technology, electronic technology, but we have to go to the basics. That's why I am dealing with that chapter also. When you push the button of keyboard of the computer, it will create the impulses, electric impulses. So that impulse would move the electron. And you all know that computer runs in binary language 0, 1. 0 is off current, 1 is on current. So the fluctuation of currents with the traveling of electron would become the data in the computer, the processing in computer, the actual impulses in computer. So that much information is sufficient. Basically, electronic evidence means where the use of electron is made in that gadget, and it gives certain things to us, it will be crudely called as electronic evidence. In fact, electronic evidence is crude term. It is misnomer. Why? I will tell. If you see If you see the entire structure of Evidence Act, then you will come across the term electronic record, not electronic evidence. So where to see first what is the meaning of electronic record? एक थोडंसं आपला BSA ओपन करा बरं. डॉक्युमेंटची डेफिनेशन घे, डॉक्युमेंटची BSAची सेक्शन 21D document. Document means any matter expressed or described or otherwise recorded upon any substance by means of letters, figures or marks or any other means or by more than one of those means intended to be used or which may be used for the purpose of recording that matter and includes electronic and digital record. खाली या बरं थोडं. 6, clause 6, ते वरती गेलं. Clause 6, an electronic record on emails, server logs, documents on computers, laptop or smartphone, messages, website, locational evidence, and voicemail messages stored in digital devices. So, थोडंसं खाली आहे. 21D. Thank you. So, one thing is clear here, that the document is term referred for electronic and digital records. Here no use of term electronic evidence. So in that sense I said that electronic evidence is misnomer, where materially related with electronic record. So what is the basic difference in between electronic and digital records? In fact, what it is said that what it is said that you tell me I forgot. If you teach, I remember. But if you get me involved, then I learn. So it is expected. बाकी माईक आहे का कोणाकडे? खाली खाली सर्क्युलेट करण्यासारखं आहे माईक आहे? देता माईक मग थोडंसं खाली कोण बोलणार असेल तर. So I am expecting that your involvement should be there so that we can learn something from you also. So what is the difference in between electronic and digital record? Okay, I think that you are already exhausted. I will not take much time for that. Electronic record and digital record, the difference is that digital record means it is born from computer itself. Means what? In binary language, so in digital record, that record born from computer itself in 01 language. And electronic record can be anything. In fact, electronic record is mother of digital record. Electronic record is genus, digital record is species. So if you scan the copy, upload into the computer, it would become electronic record, because it is not born from the computer. Still, it is covered by that term electronic record. So electronic record and digital record, you have to get certain idea about those topics in your mind. Unless you are getting certain idea, you will not be in position to go to the further step of production, admissibility and probative value of that evidence. So we'll do one thing. I will in fact skip everything in between, because I decided to read each and every provision after amendment of 2020 in Indian Evidence Act due to enactment of Information Technology Act. But now we have no time for that. So we'll directly march towards the production, admissibility and probative value of electronic record. And we are on the subject, on the topic that we are going to ascertain what is the real meaning of electronic record. Because unless we are getting real meaning, we will not be in position to use it in our day-to-day court work. So there are separate definitions given under Section 2T of the Information Technology Act. The electronic record is defined. But what the Indian Evidence Act or the Evidence Act or the Bharatiya Sakshi Adhiniyam requires, we'll first see that thing, and thereafter we will turn to other definitions also. So Section 65 capital A and 65 capital B. Passes A and passes B हे करा ना. I am repeatedly saying that we are restricted for the evidentiary value to the electronic record. In fact, electronic record does not mean electronic evidence. Electronic evidence would cover everything. Electronic gadget, electronic record, digital record would be covered under electronic evidence. So electronic record is totally different concept. How we are now seeing it. And entire Evidence Act. In fact, since 1st of July 2024, Bharatiya Sakshi Adhiniyam came into existence, or it is enforced. In fact, it came into existence in 2023, but it has been enforced from 1st of July 2024. But the matter pending before court prior to that date, means 1st of July 2024, every procedure would be governed by Indian Evidence Act 1872. See the nicety of this act. This act is in existence since last 154 years. Still it is compatible to this modern era, this artificial intelligence era also. So it is the nicety of that act. So whenever the terms or whenever the statute we refer, we are going to refer under Indian Evidence Act only, not BSA, because that after 2 years, if Jagtap Vakil would arrange again this kind of conclave or symposium, at that time we will talk on BSA, because after 2 years there would be need of BSA. So still now we are having handy with us the Indian Evidence Act. So Section 65 capital A and 65 capital B, we are looking at these provisions with a view that what is the production, admissibility and probative value of the electronic record. And we are going to first clear ourselves what is the real meaning of electronic record. We will directly go to Section 65B subsection 1. That's why I need someone to read that provision. To read? हाँ, mic जर दिला तो.
Section 65B, Admissibility of Electronic Records.
65B, subsection 1.
Subsection 1, notwithstanding anything contained in this Act, any information contained in electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media produced by a computer, hereinafter referred to as the computer output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without any further proof or production of the original as evidence, or any contents of the original or of any fact stated therein of which direct evidence would be admissible.
Okay, sufficient, madam. Thank you. So what it suggests, the electronic record, keywords are which is printed on paper, stored, recorded or copied in optical or magnetic media. Very simple. Optical or magnetic media means memory chip, SD card. So media produced by the computer, hereinafter referred as computer output. Simple meaning is that electronic record means what computer gives output to us. Print out. If the computer data is copied on CD, that is electronic record. So you can arrange this analogy to anything. So the record means if we are forming only the image of document, it is not correct. What computer gives is stored, suppose in memory card, suppose on DVD, suppose on CD. It will become an electronic record. So what computer gives you is an electronic record. That is what it states. So bracket is there, hereinafter referred to as the computer output. So what output is given by computer is electronic record. Shall be deemed also to be also a document. हे जे देणार आहे इलेक्ट्रॉनिक रेकॉर्ड, इट बिकम्स डॉक्युमेंट असं त्यांना म्हणायचं इथं. आपण एक उदाहरण घेऊन पुढे चालूया. सपोज वन डिफॉमेटरी ईमेल इज रिसीव्ड or even threatening email is received on mobile phone. You couple that mobile phone to the printer and printout is taken. That printout is an electronic record. What output is given is electronic record. And it is deemed as a document. And now just we saw the definition of document under BSA. It has included the digital and electronic record also. So one and all, what computer gives output is called as document. We have to impress that term in our mind. Document, if the conditions mentioned in the section are satisfied in relation to the information and computer in question, shall be admissible. ते डॉक्युमेंट रिअल डॉक्युमेंटच्या डेफिनेशनमध्ये कधी येईल? रिअल डॉक्युमेंटच्या डेफिनेशन कुठे दिल्यात आपल्याला? सेक्शन 61, 62 ऑफ एव्हिडन्स ॲक्ट. सो रिअल डॉक्युमेंटच्या डेफिनेशनमध्ये यायसाठी काय करायचं आहे ते खाली लिहिलेलं आहे तिथं. बाकीच्या कंडिशन ज्या सेक्शनमधल्या आहेत त्या जर फुलफिल केल्या इलेक्ट्रॉनिक रेकॉर्डनी, इट इज इक्वल टू डॉक्युमेंट. जे आपण खरेदी खत आपल्या हातात असतं किंवा कुठलाही डॉक्युमेंट, 7/12चा उतारा असतो, 173चा फायनल रिपोर्ट आपल्या हातात असतो, हे डॉक्युमेंट व्हायसाठी त्याला सर्टन कंडिशन्स फॉलो करावं लागतील असं तो सेक्शन सांगतोय. मग वन थिंग इज क्लिअर, व्हॉट द आउटपुट इज गिवन बाय द कॉम्प्युटर इज अन इलेक्ट्रॉनिक रेकॉर्ड. इज इट क्लिअर? any kind of output, any kind of output means what? In crude words or crude language we can say that it is no more the part of that computer which has given it out. So that would be an electronic record. Why we are stressing much on this provision? त्यासाठी आपल्याला सेक्शन 65A वाचायला पाहिजे कॅपिटल. What section 65A reads? Special provisions as to evidence relating to the electronic record. The contents of electronic record may be proved in accordance with the provisions of section 65B. इलेक्ट्रॉनिक एव्हिडन्स किंवा इलेक्ट्रॉनिक रेकॉर्ड हे फक्त ह्या प्रोव्हिजननी प्रूव्ह करायचं आहे आपल्याला, असं सेक्शन 65A चं मॅन्डेशन नाही. त्यासाठी आपण हे प्रोव्हिजन वारंवार वाचायला पाहिजे. आणि हे जर एकदा आपलं क्लिअर झालं तर यू विल नॉट बी फंबल्ड ऑन एनी काइंड ऑफ इलेक्ट्रॉनिक रेकॉर्ड, दो इट बी मेसेज फ्रॉम व्हॉट्सॲप, फेसबुक, एनी सोशल मीडिया, गुगल प्रिंटआउट, वॉट एव्हर मे बी. You will not be having any dilemma if you study these provisions efficiently. So section 65A suggests that electronic record is required to be proved only by the scheme given under section 65B. Is it clear? Okay, we'll proceed further. So what would be the conditions? And the electronic record will be the computer output, and from which it has given output is computer data, obviously. So computer data is said as original. Second last line, information and computer in question and shall be admissible in any proceedings without further proof or production of the original. Original means what here? The data stored in computers. It is original. and what it has given as output is an electronic record. So we'll proceed further then. Firstly, we have differentiated the original and electronic record. For original, here is no scheme is provided. For original means actual data stored in motherboard or CPU, you can crudely say. So the part of data in computer is called original, and from data what computer has given is output. That output is called as electronic record. And for proving electronic record, the scheme is given here. Why the scheme is not given for original? Because original can be easily produced before the court. There would not be any question of authentication or other things. Because original is there. Let court to go through it, find it out, what is its value. So original, there would not be any rule provided here. Original is required to be proved under section 5960. Oral evidence. Oral evidence means section 59 of the Evidence Act. Oral evidence. Every fact except the document, content of document or content of electronic record is to be proved by oral evidence. Section 59 says. And what about section 60? Section 60 says the oral evidence must be direct. What is the meaning of direct? The fact conceived by our five senses is direct evidence. So, once the fact is required to be proved, then we have to go there. We'll discuss it later on. But we will first concentrate on the scheme by which the electronic record is required to be proved. So, whether there is any doubt in between original and electronic record, here no word is used as primary evidence, no word is used as secondary evidence. Keep it in your mind. Because generally we are, in fact, having certain sort of ambiguous notions of the regarding electronic record, as it is secondary evidence. Because it is the amendment in section 65. Section 65 provides what is the secondary evidence. So it has nothing to do with secondary evidence. For our appreciation, we will see why it is referred as secondary evidence. But in entire scheme, there is no use of word like secondary evidence, primary evidence. Here the only words are used, material words are used, original and document. And the electronic record is deemed as a document as per this provision. So we'll move further. Madam, please read subsection 2.
The conditions referred to in subsection 1 in respect of the computer output shall be the following, namely A. The computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purpose of any activities regularly carried on over that period by the person having lawful control over the use of the computer. B. During the said period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities.
Okay. Why we are reading this? Because of those words, na? Last line.
The conditions referred. The conditions referred to in subsection 1 that I read earlier in respect of the computer output that sir had explained shall be following, namely, and then it includes A, B, C, D.
Okay. So the conditions which are referred in section 65B subsection 1, our electronic record has to qualify. Our conditions are given here. So that electronic record should be qualified by these conditions. Okay. He's talking on mobile phone. I think someone has raised query. Okay. So the conditions are in respect of, in short, the information is faded correctly. During feeding of information, the computer is running properly without having any mistake. The data was fed properly. So regularity of feeding of data and regularity of maintenance of the machine are those conditions here. If we take an example of email generated from computer, it means those conditions are required to be seen that the data was fed properly. In fact, there is a presumption under section 89 capital A of the Indian Evidence Act. We'll go later on to that aspect, that the information fed in the computer in respect of email exchange is required to be presumed as done regularly. But here, the regularity is required to be brought on record. And how it is to be brought on record? By way of certificate. So we'll go there. First, we'll complete this portion. Everything regularly is done in respect of electronic record. Those are the conditions required here. And if our electronic record passes these conditions, then it would become a valid document to be admitted in evidence. Okay. Madam, please read subsection 4.
Throughout the material part of the said period, I am reading C.
Project it.
The same is there on the computer.
No, you have to scroll it up.
Upwards.
Subsection 4. Subsection 4.
Subsection 4. In any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things that is said,
Please take a pause here. Now, for getting admitted that electronic evidence, what required? So, it is required certificate under subsection 4. That is what under subsection 4 states to us. In any proceeding where it is desired to give the statement means electronic record, in evidence by virtue of this section, a certificate doing any of the following things to be given.
A. Identifying the electronic record containing the statement and describing the manner in which it was produced. B. Giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. C. Dealing with any of the matters to which the conditions mentioned in subsection 2 relate.
Yes. You may take a pause. Original? We are not discussing about original. That is what I am telling. Original is totally different aspect. Original is remained with computer. Original is remained with computer, and what computer has given to us is computer output, and it is called as electronic record. We are dealing with the proof of electronic record. Everything is there covered for the electronic record.
Properly elaborate.
You may speak into mic.
हेलो, उसका स्पष्टीकरण दीजिए डेफिनेशन में. डेफिनेशन और उसमें क्या क्या इंक्लूड हो सकता है, वो कैसा, वो एक्सप्रेस कैसा किया जा सकता है.
Simple.
Electronic original record.
Okay, I got it. Simple thing is that, suppose you may take one example of computer. Obviously, we are dealing with the content of computer. We are saying it as a data stored in CPU. So that data would be original. And from that data, what computer generates to us? Printout. Or if we directly burn the set, means directly copy the data on CD, VCD, DVD. So those CD, VCD, DVD become electronic record. Very simple. So the output given by the internal data is called as computer output, and computer output is an electronic record. And what remains with computer means data is original. It is very simple. So what requires, what conditions required? Subsection 4, in any proceeding where it is desired to give statement in evidence by virtue of this section, a certificate doing any of the following things. तर त्या सर्टिफिकेटमध्ये ह्या ABC ह्या कंडिशन आल्या पाहिजेत. हे आपण कशासाठी करतोय सगळं? सो दॅट द इलेक्ट्रॉनिक रेकॉर्ड इन एनी फॉर्म इज मेड ॲडमिसिबल इन एव्हिडन्स. ह्यासाठी आपण करतोय, कारण डॉक्युमेंटच्या ज्या प्रोव्हिजन आहेत त्या ह्याला लागणार आहे सगळ्या. मग ते डॉक्युमेंट म्हणून ट्रीट करायसाठी काय करावं लागेल, त्यासाठी इथे हे दिलेलं आहे. सर्टिफिकेट द्यायचं, त्या सर्टिफिकेटमध्ये आयडेंटिफाईंग द इलेक्ट्रॉनिक रेकॉर्ड. आयडेंटिफाईंग द इलेक्ट्रॉनिक रेकॉर्ड मीन्स व्हॉट? समजा एक उदाहरणच घेऊ आपण, पुढं चालू आहे म्हणजे ते थोडंसं क्लिअर होत जाईल. कॉम्प्युटरमधून एखादा ईमेल आला आहे आपल्याला जो इन्क्रिमिनेटिंग आहे, त्या ईमेलचं आपण कॉपी घेतलेली आहे, प्रिंटआउट घेतली आहे, हार्ड कॉपी घेतलेली आहे, असं आपल्याकडे गृहीत धरून चालू आहे. आणि ती हार्ड कॉपी आपल्याला एव्हिडन्समध्ये द्यायची कोर्टापुढं. आता मी ज्या मगाशी सगळ्या डेफिनेशन सांगितल्या 65B1 सेक्शन 2T, इलेक्ट्रॉनिक रेकॉर्ड म्हणजे द आउटपुट गिवन बाय द कॉम्प्युटर, म्हणजे जे प्रिंटआउट दिले कॉम्प्युटरने ते इलेक्ट्रॉनिक रेकॉर्ड असेल. आणि ते आपल्याला आता प्रूव्ह करायचं कोर्टापुढं. पहिल्यांदा ते डॉक्युमेंट म्हणून पुढं आणायचं. हे सगळं आपण काय करायला लागलो आहे, तर ते एक रिलायबल डॉक्युमेंट म्हणून आपण पुढं आणायचं कोर्टापुढं. आणि एकदा रिलायबल म्हणून डॉक्युमेंट म्हणून पुढं आल्यानंतर ते परत प्रूव्ह करायचं आहे. म्हणजे आपल्याला सगळ्यांना माहिती आहे प्रोडक्शन ऑफ डॉक्युमेंट इज डिफरंट दॅन ॲडमिसिबिलिटी अँड इट्स प्रोबेटिव्ह व्हॅल्यू. ते आपण परत डिटेलमध्ये बघूया. तर आपल्याला ते डॉक्युमेंटच्या डेफिनेशनमध्ये आणण्यासाठी ह्या सगळ्या गोष्टी आपण करायला लागलो. त्याच्यामध्ये क्लॉज ए मध्ये आयडेंटिफाईंग द इलेक्ट्रॉनिक रेकॉर्ड कंटेनिंग द स्टेटमेंट डिस्क्रायबिंग द मॅनर इन विच इट वॉज प्रोड्युस्ड. म्हणजे समजा आता तुम्ही इथं हार्ड कॉपी आपण काढलेली आहे ईमेलची, तर आपण त्या सर्टिफिकेटमध्ये पहिल्यांदा काय लिहिणार आहे, हार्ड कॉपी ऑफ ईमेल. म्हणजे आपण असर्टन केलं ते काय आपल्याकडे इलेक्ट्रॉनिक रेकॉर्ड ज्या क्लॉज ए प्रमाणे. समजा DVD असेल, VCD असेल, तर ती VCDचं लाईन येईल तिथं की इलेक्ट्रॉनिक रेकॉर्ड इज इन फॉर्म ऑफ DVD, इज इन फॉर्म ऑफ VCD. हे पहिलं लाईन येईल सर्टिफिकेटमधलं. दुसरी लाईन काय येईल, आयडेंटिफाईंग द इलेक्ट्रॉनिक रेकॉर्ड. दुसरी लाईन काय येईल, गिविंग सच पर्टिक्युलर्स ऑफ एनी डिव्हाइस इन्वॉल्ड इन प्रोडक्शन ऑफ द इलेक्ट्रॉनिक रेकॉर्ड ॲज मे बी अप्रोप्रिएट फॉर द पर्पज ऑफ शोईंग दॅट द इलेक्ट्रॉनिक रेकॉर्ड वॉज प्रोड्यूस्ड बाय दॅट कॉम्प्युटर. ज्या कॉम्प्युटरमधनं आपण ते काढलं त्याचे डिटेल्स, मग त्याचा मेक, त्याचं मॉडेल जे काय असेल ते दुसऱ्या लाईनमध्ये येईल आपल्या. ते मोबाईल फोनमधनं काढलं असेल तर मोबाईल फोनचं डिस्क्रिप्शन, कंपनी आणि त्याचं मॉडेल हे दुसऱ्या लाईनमध्ये येईल. हे सर्टिफिकेटमधलं चाललं आहे. आणि तिसरी लाईन महत्त्वाची, डीलिंग विथ एनी ऑफ द मॅटर्स टू विच द कंडिशन्स मेन्शन्ड इन सबसेक्शन 2 रिलेट. आपण सबसेक्शन 2 मध्ये मगाशी कंडिशन काय वाचल्या, 65B सबसेक्शन 2 ह्या कंडिशन्स आपण काय वाचल्या, डाटाची रेग्युलरिटी पाहिजे, कॉम्प्युटर रेग्युलरली मेंटेन केलेला पाहिजे, डाटा फीड रेग्युलरली केला पाहिजे, ह्या कंडिशन होता त्याच्यामध्ये. त्या कंडिशन याच्यामध्ये मेन्शन करायच्या सीला. म्हणजे काय काय येईल त्या सर्टिफिकेटमध्ये, पहिलं तरी येईल काय इलेक्ट्रॉनिक रेकॉर्ड आहे. आपल्या उदाहरणाप्रमाणे प्रिंटआउट हार्ड कॉपी कॉम्प्युटरमधनं आपण ईमेलची काढलेली ती असर्टन केली. काही ठिकाणी DVD VCD असेल ती तिथं ती लाईन येईल. त्यानंतर दुसरी लाईन काय येईल आपली, दुसरी लाईन काय येईल तर ते ज्या कॉम्प्युटरमधनं काढलं त्या कॉम्प्युटरचं डिस्क्रिप्शन आलं पाहिजे, कंपनी, मेक, मॉडेल. आणि त्याच्यानंतर C की तो जो कॉम्प्युटर सिस्टीम आहे ती रेग्युलरली मेंटेन केलेली आहे हे त्या सर्टिफिकेटमध्ये आलं पाहिजे. आता हे सगळं कशासाठी करायचं आपल्याला, व्हॉट इज द नेसेसिटी ऑफ डुईंग ऑल दोज थिंग्स. बिकॉज we have to relate now that electronic record with original computer. That electronic record is related to original computer so that there would be authentication established by the certificate. ह्यासाठी ते सर्टिफिकेट द्यायचं आहे. इलेक्ट्रॉनिक रेकॉर्ड हे क्ष नावाच्या कॉम्प्युटरकडनं घेतलेलं आहे. तो क्ष नावाचा कॉम्प्युटर सगळ्या बाबतीमध्ये रेग्युलर होता हे रेकॉर्डला आणायचं आहे आपल्याला. विदाउट एनी टेक्निकल फ्लॉज, विदाउट एनी टेक्निकल डिफॉल्ट्स तो होता. म्हणून हे डॉक्युमेंट ऑथेंटिकेटेड आहे. हे करायसाठी आपल्याला हे सर्टिफिकेट आणायचं आहे. इज देअर एनी प्रॉब्लेम अप टिल नाऊ रिगार्डिंग सर्टिफिकेट. सर्टिफिकेट हे फक्त इलेक्ट्रॉनिक रेकॉर्डला ओरिजिनल कॉम्प्युटरशी जोडायचं आहे आणि ओरिजिनल कॉम्प्युटर हा चांगल्या स्थितीत आहे एवढंच कोर्टापुढं आणायचं आपल्याला ते सगळं देऊन, सर्टिफिकेट देऊन. नाऊ हू हॅज टू गिव्ह द सर्टिफिकेट. इट इज मटेरियल क्वेश्चन. चला पुढे वाचूया मॅडम.
And purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate. And for the purposes of this subsection, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it.
ओके, थँक्यू. सर्टिफिकेट कोणी द्यायचं हे अँड परपोर्टिंग टू बी साइंड बाय अ पर्सन ऑक्युपाईंग अ रिस्पॉन्सिबल ऑफिशियल पोझिशन इन रिलेशन टू द ऑपरेशन ऑफ द रिलेवंट डिव्हाइस ऑर द मॅनेजमेंट ऑफ द रिलेवंट ॲक्टिव्हिटीज. जो कस्टोडियन आहे त्या कॉम्प्युटरचा मॅनेजमेंटमधला आहे त्यांनी सर्टिफिकेट दिलं पाहिजे असं ते म्हणतात. म्हणजे आपल्या कॉम्प्युटरचा जो कस्टोडियन आहे मॅनेजमेंटची ज्याच्या मॅनेजमेंट खाली आहे त्यांनी सर्टिफिकेट दिलं पाहिजे असं म्हटलं आहे. ऑर ते मॅनेजरियल पोस्टमधला असेल त्यांनी दिलं पाहिजे. म्हणजे ॲक्च्युअल कस्टोडियननं दिलं पाहिजे किंवा मॅनेजरियल पोस्टमध्ये असले त्यांनी दिलं पाहिजे. आता इथं फक्त एक वर्ड वाढवला नवीन BSAमध्ये. BSAमध्ये प्रोव्हिजन आहे तशीच घेतली आहे. सेक्शन 62 अँड सेक्शन 63 BSAमध्ये आपण हे बघतोय सगळं सेक्शन 63 BSAमध्ये घेतलेलं आहे. ह्या प्रोव्हिजन ज्या बघतोय आपण ह्या 65B(4) मधल्या बघतोय इव्हिडन्स ॲक्टच्या. पण ही सगळी प्रोव्हिजन सेक्शन 62 BSAमध्ये घेतलेली आहे, नवीन कायद्यामध्ये घेतलेली आहे. फक्त काय वाढवलं आहे तेवढं सांगतो. ऑर द मॅनेजमेंट ऑफ द रिलेवंट ॲक्टिव्हिटीज हा शब्द झाल्यानंतर तिथं अँड एक्सपर्ट असा शब्द घातला आहे. अँड एक्सपर्ट म्हणजे नवीन कायद्याप्रमाणे 2 सर्टिफिकेट अपेक्षित आहेत. एक तर मॅनेजमेंट किंवा ज्याच्या कस्टडीमध्ये आहे त्यांनी द्यायचं आहे आणि दुसरं एक्सपर्टनी द्यायचं आहे. हे कधी 1 जुलै 2024 नंतर. 1 जुलै 2024च्या पूर्वी फक्त कुणी द्यायचं आहे सर्टिफिकेट. ऑर शब्द आहे सगळीकडे बघा. ऑर ऑप्शनल क्लॉजेस आहेत सगळीकडे. इन रिलेशन टू द ऑपरेशन ऑफ द रिलेवंट डिव्हाइस ऑर द मॅनेजमेंट ऑफ द रिलेवंट ॲक्टिव्हिटीज. म्हणजे जो माणूस ॲक्च्युअल कॉम्प्युटर चालवतो तो किंवा ज्याच्या मॅनेजमेंटमध्ये तो कॉम्प्युटर आहे त्यांनी ते सर्टिफिकेट द्यायचं आहे असं हे जुनं आपल्याला सांगत होतं. एकच सर्टिफिकेट जुन्या कायद्यामध्ये अपेक्षित होतं. आता ह्याच्यामध्ये हा प्रश्न येईल का कोणाला तुम्हाला की बाबा समजा माझ्या मोबाईल फोनवर एक मेसेज आला आणि तो मेसेजचं मी प्रिंटआउट काढला आणि कोर्टापुढे दाखल केलं. प्रिंटआउट म्हणजे काय असेल? इलेक्ट्रॉनिक रेकॉर्ड. ते कोर्टापुढे मी दाखल केलं. सर्टिफिकेट कोणी द्यायचं? आपण हे सगळं जुन्या कायद्याप्रमाणे बघतोय कारण अजून सगळं जुन्या कायद्याप्रमाणेच प्रोसिजर चालू आहे कोर्टापुढं. जो कस्टोडियन आहे कॉम्प्युटर त्याने ज्या कॉम्प्युटर मोबाईल फोन कॉम्प्युटर आहे हे तरी सगळ्यांना मान्य आहे ना. मोबाईल फोन ज्याच्या ताब्यात आहे त्या माणसाने ते सर्टिफिकेट द्यायचं आहे. एवढं सिम्पल आहे ते. ऑफिसचा समजा कॉम्प्युटर आहे एखाद्या प्रायव्हेट लिमिटेड कंपनीचा कॉम्प्युटर आहे. त्या प्रायव्हेट लिमिटेड कंपनीच्या कॉम्प्युटरमधून एक थ्रेटनिंग मेसेज आला आहे. तो प्रिंटआउट काढली. ती प्रिंटआउट कोर्टापुढे दिली आहे. आता त्या प्रिंटआउटसोबत सर्टिफिकेट कोणी द्यायचं आहे? एकतर त्या ऑफिसमध्ये तो कॉम्प्युटर डायरेक्टली चालवणारा त्या माणसाने द्यायचं आहे किंवा मॅनेजरियल पोस्टमध्येच्या ऑफिसमध्ये जे कोण लोक असतील त्यांनी द्यायचं आहे. व्हेरी सिम्पल. आणि ते सर्टिफिकेट कसं द्यायचं हे आपण बघितलं कुठल्या फॉर्मॅटमध्ये द्यायचं आहे ते. हे सगळं केल्यानंतर काय होईल? इलेक्ट्रॉनिक रेकॉर्ड प्लस सर्टिफिकेट हे कोर्टापुढे दिल्यानंतर काय होईल ते? इट बिकम ॲन ऑथेंटिकेटेड डॉक्युमेंट. आधी तर ते डीम्ड डॉक्युमेंट आहे पण ते कोर्टापुढे ह्या प्रोसिजरने आणल्यामुळे हे ऑथेंटिकेटेड डॉक्युमेंट तुमच्या पुढे आणलं आहे. आता त्याची ॲडमिसिबिलिटी आणि प्रोबेटिव्ह व्हॅल्यू कोर्टाने ठरवावी. इथपर्यंत आपण आलो. ह्याच्यामध्ये काही वेदर एनी डिफिकल्टी इन गेटिंग एनी आयडिया अबाउट धिस एंटायर प्रोसिजर? आता हे जी प्रोसिजर आहे ही आपण सगळ्याबरोबर रिप्लेस करूया. CCTV फुटेजेस. CCTV फुटेजेसचे पोलीस काय करतात इन्व्हेस्टिगेशनमध्ये? समजा चोरीची केस आहे. चोरांचं CCTV फुटेज CCTV कॅमेऱ्यावर कॅप्चर झालं आहे. CCTV म्हणजे सगळ्यांना माहिती ना क्लोज सर्किट TV ज्याच्यामध्ये सर्किट क्लोज्ड असतं एका DVR बरोबर ज्या डिव्हाइस बरोबर. DVR म्हणजे डिजिटल व्हिडिओ रेकॉर्डर, त्या DVRला ते कनेक्ट केलेलं असतं सगळं चेन, त्याला CCTV म्हणा, क्लोज सर्किट TV. ते आपले जे TV असतात घरी ते क्लोज सर्किट नाही, ते ओपन सर्किट, कारण सगळ्या थ्रूआउट जगामध्ये ते चालतात. तर CCTV परत त्याच्यात 3 टाईप आहेत. एक म्हणजे ऑन इट्स ओन, त्याच्यामध्ये स्वतः कॅमेरा पण असेल आणि मेमरी पण असेल. दुसरा असेल तो सर्किटला जोडलेला असेल, आणि तिसरा असेल तो वायफायला आपण त्याला वायर कनेक्शन नसणार. असे 3 टाईप आहेत सध्या CCTV मधले. CCTVचं आता आपण उदाहरण घेतोय की चोरी झालेली आहे, CCTV फुटेजेस मिळालेले चोराचे. ते CCTV फुटेजेस इन्व्हेस्टिगेटिंग ऑफिसरने एक एक्सपर्ट बोलवला. खरं तर एक्सपर्ट बोलवायची गरज आहे का इथं? सेक्शन 65B सबसेक्शन 4 क्लॉजेस A to C काय सांगतात आपल्याला? जो ॲक्च्युअल DVRचं मॅनेजमेंट करतो त्या माणसाने जरी दिलं सर्टिफिकेट तरी सफिशियंट आहे. पण पोलीस एक्सपर्टला बोलवतात. एक्सपर्ट त्यातलं फुटेजेस काढतो जे रिक्वायर्ड पोलिसांना चोरीचं, ते पेनड्राईव्हवर घेतो. आता एक्सपर्ट इथं कुठे रिलेव्हंट होईल हो? कारण एक्सपर्ट हा तर काय कॉम्प्युटर चालवलं नाही त्याने, म्हणजे DVR त्यांनी स्वतः चालवलं नाही किंवा त्याच्या मॅनेजमेंटमध्ये पण नाही आहे. मग ह्या 2 क्लॉजेसमध्ये कुठं कवर होईल तो? कारण आपल्याला 2 कंडिशन पाहिजेत. एक तर तो चालवणारा पाहिजे किंवा एक तर तो मॅनेजमेंटच्या कॅपॅसिटीमध्ये पाहिजे. मग इथे एक्सपर्ट येतो कुठं? तर ते तिथं लास्ट लाईनमध्ये येतो. बघा, आपण लास्ट लाईन काय वाचली आता हिची? सबसेक्शन 4ची लास्ट लाईन. सेक्शन इट शॅल बी सफिशियंट फॉर अ मॅटर टू बी स्टेटेड टू द बेस्ट ऑफ द नॉलेज अँड बिलीफ ऑफ द पर्सन स्टेटिंग इट. एक्सपर्टला जर असं वाटलं की ती सिस्टीम चांगली चालली आहे, त्याला वाटलं म्हणजे त्याचा बिलीफ आहे किंवा त्याला माहिती असेल, जो कोण सर्व्हिस प्रोव्हायडर असेल त्याला, किंवा एक्सपर्टला वाटतंय की कॉम्प्युटर सिस्टीम ज्या अर्थी हे देते, ते DVR ज्या अर्थी हे आउटपुट देतोय त्या अर्थी तो चांगला फंक्शनिंगमध्ये आहे, तिथं बिलीफ हा वर्ड आहे, तर याच्यामध्ये तो एक्सपर्ट पण कवर होतो. म्हणजे मॅनेजमेंटमधला जरी नसला, ॲक्च्युअल ऑपरेट करणारा मॅनेजर जरी नसला, समजा बाहेरचा एक्सपर्ट आला आणि त्यानं ते काढलं CCTV फुटेज, तर ते त्याचं नॉलेज आणि बिलीफमध्ये येईल ते, आणि त्याचं सर्टिफिकेट व्हॅलिड असेल. तर आपल्या केसमध्ये पोलिसांनी इन्व्हेस्टिगेशनमध्ये एक्सपर्ट बोलवला. त्या एक्सपर्टच्या पेनड्राईव्हमध्ये ते कन्सर्न CCTV फुटेजेस घेतले आणि कोर्टापुढं तो पेनड्राईव्ह दिला. आता तो आपल्याला प्रूव्ह करायचा आहे, म्हणजे प्रॉसिक्युटरला प्रूव्ह करायचं आहे. त्याच्यामध्ये ह्या सगळ्या स्कीमप्रमाणे पेनड्राईव्हवर जे CCTV फुटेजेस कॉपी केलं असेल त्याला काय म्हणायचं आपण आता? इलेक्ट्रॉनिक रेकॉर्ड. ओरिजिनल कुठं असणार आहे? DVRमध्ये असणार आहे. डिजिटल व्हिडिओ रेकॉर्डर जो त्या CCTVला जोडलेलं जे ॲपरेटस आहे छोटं त्याच्यामध्ये असणार आहे. ओरिजिनलशी आपला काय संबंध आहे का इथं? पेनड्राईव्ह म्हणजे इलेक्ट्रॉनिक रेकॉर्ड आहे, ते कसं प्रूव्ह करायचं आपण बघितलं सगळं. एक्सपर्टनी काढलं तर एक्सपर्टनी सर्टिफिकेट द्यायचं 65B4 प्रमाणे. त्यांना म्हणायचं की माझ्या नॉलेज आणि बिलीफप्रमाणे ती सिस्टीम सगळी चांगली चालू असली पाहिजे. इलेक्ट्रॉनिक रेकॉर्ड मी पेनड्राईव्हवर घेतलं आहे ते असर्टन केलं पाहिजे. DVRची कंपनी लिहिली पाहिजे आणि तो DVR चांगल्या फंक्शनिंगमध्ये असला आहे असं माझ्या माहितीप्रमाणे ते आहे असं म्हटलं पाहिजे त्यांनी. तर हे व्हॅलिड सर्टिफिकेट जाईल. CCTVचं झालं. आता व्हॉट्सअप मेसेज जो तुम्हाला येईल डायरेक्टली, त्या मेसेजेसला तुम्हाला सगळी सर्टिफिकेट देता येतील ना ह्याची? ज्याच्या हातात मोबाईल फोन आहे त्याच्या हातामध्ये. समजा ह्याच्यामध्ये कॉम्प्लिकेटेड आपण केस करूया की तो सोशल मीडियावर ग्रुपमध्ये तो शेअर झाला, तो दिला आणि तो तुम्ही बघितला, तरीसुद्धा तुम्हाला इथं काय दाखवायचं आहे फक्त की तो प्रॉपर जनरेट झालेला आहे. तुमचा कॉम्प्युटर म्हणजे मोबाईल फोन तुमचा चालू कंडिशनमध्ये आहे, त्याची कंपनी अशी अशी आहे, त्याची कॅपॅसिटी अशी अशी आहे आणि त्या मोबाईल फोनमधनं मी ही प्रिंट काढलेली आहे. आता समजा मोबाईल फोन त्या मेसेजसहित कोर्टापुढे दिला तर काय होईल? विदाऊट प्रिंटआउट काढता ओरिजिनल होईल ना ते आपल्या डेफिनेशनप्रमाणे 65B1 प्रमाणे ओरिजिनल होईल. बिकॉज इट इज स्टील कंटेंड इन दॅट मोबाईल फोन. ते ओरिजिनल होईल. त्याला 65B4चं सर्टिफिकेट द्यायची गरज आहे का? आहे का गरज? देर इज नो नेसेसिटी टू इश्यू 65B4 सर्टिफिकेट इफ ओरिजिनल इट सेल्फ इज गिव्हन बिफोर द कोर्ट. काही कॉम्प्युटरच्या हार्ड डिस्क आणतात पोलीस जप्त करून, त्याच्यासाठी 65B4चं सर्टिफिकेट द्यायची गरज नाही. बिकॉज आपण 65B1 प्रमाणे बघितले की ओरिजिनलला गरज नाही, इलेक्ट्रॉनिक रेकॉर्डला फक्त गरज आहे. त्यामुळे ही जे करोलरी आपण जी सेक्शनची 65A आणि 65B ही जी बघितली, ही सगळ्या इलेक्ट्रॉनिक रेकॉर्डला लागते सगळ्या. त्यामुळं आपली पोझिशन अशी कधीच होऊ द्यायची नाही की आता नेमकं करायचं काय ह्याच्यामध्ये. असर्टन 2 गोष्टी फक्त करायच्यात, ओरिजिनल काय आणि इलेक्ट्रॉनिक रेकॉर्ड काय. ओरिजिनल जे आहे ते कॉम्प्युटरमध्ये राहिलं आहे, इलेक्ट्रॉनिक रेकॉर्ड म्हणजे कॉम्प्युटरने आउटपुट जे दिलं तुम्हाला ते इलेक्ट्रॉनिक रेकॉर्ड आहे. जर आउटपुट जर तुमच्याकडे असेल तर ते 65B4 प्रमाणे सर्टिफिकेट दिलं पाहिजे त्याला. का तर ते आउटपुट त्या ओरिजिनल कॉम्प्युटरला जोडायसाठी. साधारणपणे आयडिया लक्षात आली 65A आणि 65B. 65 आणि ह्याच्या व्यतिरिक्त दुसरं काहीही लागत नाही. ऑथेंटिकेट डॉक्युमेंट आहे इलेक्ट्रॉनिक रेकॉर्डचं कोटापुढं आणण्यासाठी. इन्फॉर्मेशन अँड टेक्नॉलॉजी ॲक्ट इज बेसिकली क्रिएटेड फॉर ई-कॉमर्स and certain terms are defined there which are not defined under Evidence Act. Only for that extent certain definitions are borrowed in the Evidence Act from Information Technology Act. Information and Technology Act as such has nothing to do with the evidentiary rules of getting admitted the electronic record. हे लक्षात ठेवायचं. आणि इतकं सिंपल आहे हे. There is no any deep science behind it. तर आपण आता 65A आणि 65B आपण इलेक्ट्रॉनिक रेकॉर्डसाठी बघितलं. आपण आता एक उदाहरण घेऊया, कोर्टापुढं ते प्रूव्ह करायचं आहे आपल्याला. वेळ आहे ना थोडा. एक थ्रेटनिंगचा मेसेज आला आहे आपल्या मोबाईल फोनवर आणि बऱ्याच शिव्या दिल्यात अशा ओळीनं, असे मोठ्याच्या मोठा त्याचा चार्ट झाला आहे सगळा. ऑडिओ मेसेज असं धरून चालू आहे. आता हा ऑडिओ मेसेज कोर्टापुढे प्रूव्ह कसा करायचा. ऑडिओ मेसेजचं जर प्रिंटआउट काढलं तर इट विल बिकम अ स्क्रिप्ट. त्याला काय अडचण येणार नाही. स्क्रिप्ट आहे ते परत त्याला 65B4चं सर्टिफिकेट आपण लावूया आणि पुढे जाऊया. मोबाईल फोनमध्ये सगळ्या तो मोठ्याच्या मोठा शिवीचा चार्ट आहे. त्याच्यासाठी काय केलं पाहिजे, काय आयडिया साधारण कोणाची, काय करायला पाहिजे याच्यामध्ये, ते मोबाईल फोन कोर्टापुढे दिलाय. नलवडे साहेबांचं एक जजमेंट. इनफॅक्ट आय एम नॉट डिस्कसिंग द जजमेंट्स ऑर द रूलिंग्स डिक्लेअर्ड बाय ऑनरेबल अपेक्स कोर्ट अँड हायकोर्ट. वाय? दे आर बाइंडिंग. आर्टिकल 141 ऑफ कॉन्स्टिट्यूशन states that the law declared by Supreme Court is binding upon all court in India. The word is law declared by Supreme Court. There is one article I will share if you are having group, I will share that article of former Justice B.H. Chauhan. He has interpreted that word in his so many judgments. Word law. He has interpreted that word law as a principle, legal principle declared by the Supreme Court is binding upon all the courts. And you know law precedent. Law precedent for the judgment delivered by upper courts to convert into precedent, it has to pass certain theories which we have studied long back in LLB. There are 3 theories: sub silentio, per inquirium, and stare decisis. Stare decisis means long-standing decision. Per inquirium means the decision is given ignoring the legal provisions or ignoring the earlier legal principle. Is sub silentio. The said judgment has to pass all those theories. Thereafter, it would become an precedent. And as per Article 141, it will become the legal principle. And it is binding upon the courts. No doubt, if there is third appeal, second appeal, that decision is directly binding upon the concerned parties and concerned court. But for discerning the legal principle, it has to pass all those theories. I will give you example in this case only. For getting admitted electronic evidence, chain of decisions is there of Honorable Apex Court. Starting from Navjot Sandhu, Parliament attack. That judgment said there is no requirement of giving 65B certificate, B4 certificate, because it could be taken on record as a secondary evidence. Thereafter come Anwar versus Bashir. In that judgment, Honorable Apex Court has held that no, this is the scheme. The admissibility of the electronic record is given under section 65A and B. So, the certificate is must for getting admitted that electronic record. It is Anwar versus Bashir. Thereafter comes Shafi Muhammad. Again, 3 judges judgment of Honorable Apex Court. It says that the rules of secondary evidence can be borrowed from section 63. Read with section 65. Secondary evidence can be borrowed, and there is again no necessity for bringing on record the electronic record. Without certificate, it can be brought on record. Thereafter, Thomas Bruno's judgment is there. And lastly, there is judgment of Arjun Khotkar versus Kailas Gorantal. In that judgment, all other judgments are overruled. And the law declared by Anwar versus Bashir long back has been upheld by holding that the certificate under section 65B4 is mandatory. It is required to be given. Unless that certificate is given, the electronic record can be get admitted in evidence. That is what the final decision is. But in certain contingencies, it has made exceptions. That suppose if the electronic record is to be proved against same person from whose computer it has been delivered, obviously that person who is the custodian of incriminating computer would not give you the certificate. In that case, Honorable Apex Court in Arjun Khotkar's judgment has said that the seeker, means the evidence seeker, has to file application before the court for getting aid of court, for getting certificate from that custodian. And if at all that custodian is not giving the certificate, then in that case, the principle has been upheld that the law could not compel you to do impossible. And thereafter, that electronic record can be get admitted by different provisions of the Evidence Act. But what net result is up till now of all the chain of those 5-6 Supreme Court judgments is that certificate is must under section 65B4, and unless it is given, the electronic record can't be get admitted in evidence. So we started this subject from that theory, law of precedent. Unless those theories are passed by legal judgment, it will not become precedent. And what Honorable then Justice of Honorable Apex Court B.H. Chauhan says, that unless it is passed under those theories, it will not come under Article 141. So I am not of the view that we have not to go for those judgments. We have to go for those judgments. But basically, we have to prepare ourselves the foundation on the basis of the statute, and thereafter we will go for peak. Because the judgments of Honorable Supreme Court, likewise Honorable High Court also, Article 227, Article 226. 227 is for general administration superiority. 226 for writs. They are binding, no problem. But again, those theories are required to be passed. And so, what I observed, why I am telling this, because day in and out, my junior colleagues appearing before the court, they press much themselves on the citations of Honorable High Court and Supreme Court. And when they are asked what is the basic statute, sir, they will not in position to tell. So unless the basic statute is made clear, we should not go for pick. Otherwise, only pick will be in our hand, and there would not be any foundation. So think on it. That's why we have studied all those provisions, 65 capital A and 65 capital B. Now we are on the point that how it is to be proved before the court. So I have given one example that one audio message is received to you on your mobile phone, and you have to prove now it before the court. In fact, for bringing in uniformity, there is one judgment of Honorable High Court, Honorable Bombay High Court, Justice Nalaude. In that judgment, he has held that the script is required to be prepared. And when I have gone through the concerned provisions of criminal manual, chapter 7, para 26, 24, para 24. In that para 24, it is under chapter 7 of criminal manual. Rules for production and recording of the tape recorded evidence in court. When I have gone through those rules, they are found in uniformity with that judgment of Honorable High Court. What it states, what these rules state, we are not having much time, so I will tell in substance. When the recorded audio is produced before the court, it is always to be produced with prepared script. Means A talk this thing, B talk this thing, from first sentence to last sentence. If script is not produced along with that audio recording, then court has to pass order to appoint an officer of the court for getting prepared the script, line by line, after listening to that recorded message. Thereafter, that officer has to endorse that I have verified the content of the recorded material, and thereafter I have prepared script and it is true and correct as per the original. He has to mention below that script. Thereafter, that script is required to be produced before court, and court has to give exhibit to that script. That script will be directly get admitted in evidence. There is no necessity again and again to run that recording before the court, because this is what the procedure is given under these rules. So we have to follow this procedure. Now script is ready, and these provisions are saying that it is admissible in evidence. Suppose threatening is given to me and it is recorded, and I have come before the court for giving evidence on that script or that recorded material. Now that recorded material is taken on pen drive and it is produced before the court with script. Now first procedure is that the script is required to be exhibited. Now what about material? Again in pen drive it is electronic record, the recorded communication, incriminating communication. I will enter into witness box. I will request to the court that the said recording should be run before me. Court would run that record. Why this procedure is required? Why this procedure is required? Because electronic record coupled with certificate, what ultimately it will bring on record? The authentic document will be brought on record by that procedure. Take example of sale deed. You have to prove the content of sale deed. What you will do? We'll call the attesting witness on it. Firstly, to prove that duly execution was made. Thereafter, the vendee and vendor would come before the court. Whoever may be challenging or whoever may be accepting that sale deed would tell actual what was the transaction. And thereafter, that sale deed would be exhibited because the content is proved as well as authenticity is proved. And exhibit is given and it is get admitted in evidence. Likewise, electronic record is ultimately a document. So you have to prove as per the procedure of proving the document. That procedure is given which we earlier discussed under section 5960, oral evidence, 61 and 62, documentary evidence. Content of documents are required to be proved by oral evidence, 59 and 60. So, for content, that witness has to state, before the court, if the script is there and the pen drive recording is played in the court, he would say that, sir, this person is me. It is my voice. The judge would stop that recording, note down the time on menu bar that at this certain time the witness has said it is his voice. It would become a voice sample number 1. Thereafter, again he would request to the court to run further. Thereafter, the voice of accused would come. Then he would again state to the court that, sir, please pause. This is the voice of accused. And again the court will note down the timing on menu bar and give it is sample number 2, sufficient. Now it is the duty of the court to decide who has said to whom. So this would be the procedure before the court for proving the content of document like electronic record. The content आपल्याला तसे प्रूव्ह केले पाहिजे. रिसेंटली सुप्रीम कोर्टाचं एक जजमेंट आलं. बॉम्बे हायकोर्टाने असं म्हटलं की तिथे एक इन्क्रिमिनेटिंग रेकॉर्डिंग होतं, व्हिडिओ रेकॉर्डिंग होतं, ते VCDवर घेतलेलं होतं. VCD कोर्टापुढं प्रोड्यूस केलेली होती. कोर्टाने ती स्क्रिप्ट वगैरेची न प्रोसिजर करता ती अलाउ केली एव्हिडन्समध्ये. कोर्टाने बेसिंग ऑन त्यात जजमेंट दिलं. बॉम्बे हायकोर्ट पुढं गेलं. हायकोर्टाने असं सांगितलं की त्याचं स्क्रिप्ट तयार केलं पाहिजे आणि स्क्रिप्ट तयार करून त्याला आयडेंटिफिकेशनची संधी दिली पाहिजे जे कोण इन्क्रिमिनेटिंग आयडेंटिफाय करणार असेल कोर्टापुढं. त्यामुळे ते बॉम्बे हायकोर्टाने रिमांड केलं ते मॅटर एव्हिडन्स रेकॉर्ड करायसाठी. त्याच्यावर पुढं सुप्रीम कोर्टामध्ये गेले. सुप्रीम कोर्ट असं म्हणतं की ही करायची प्रोसिजर करायची गरज नाही. बिकॉज वी नीड नॉट अ पर्सन टू लुक इन टू द कंटेंट ऑफ व्हिडिओ. इवन वी कॅन विथ बेअर आईज वी कॅन सी इट व्हॉट इज हॅपनिंग. तर तो परत हायकोर्टाकडं रिमांड केलं सुप्रीम कोर्टाने की हा इश्यू कन्सिडर करून ते मॅटर डिसाईड करून टाका. पण मग ह्याच्यावर व्हाया मार्ग एक असा काढता येईल आपल्याला की जर इन्क्रिमिनेटिंग व्हिडिओ असेल, रेकॉर्डिंग असेल, तर जेवढा इन्क्रिमिनेटिंग पार्ट आहे त्याच्यामध्ये फक्त एक शॉर्ट आपल्याला स्क्रिप्ट करता येईल. लाल शर्ट घातलेला माणसाने पिवळ्या शर्ट घातलेल्या माणसाला चापट मारली अशा पद्धतीनं एवढं स्क्रिप्ट त्या इन्क्रिमिनेटिंग मटेरियलचं करता येईल. लाल शर्टवाला माणूस जर कोर्टापुढे येणार असेल तर तो आयडेंटिफाय करेल हा लाल शर्टवाला मीच आहे, किंवा पिवळा शर्ट ज्याने चापट खाल्ली आहे तो येऊन कोर्टापुढे सांगेल हा पिवळा शर्ट घातलेला मीच आहे. कोर्टाने परत ती प्रोसिजर फॉलो करायची, पॉज करायचं आहे, त्या पॉजला एक सॅम्पल द्यायचं आहे, ते सॅम्पल तिथं टायमिंगसहित नोट करायचं आहे एव्हिडन्समध्ये आणि पुढे ॲप्रिशिएट करताना ते वाचायचं आहे पिवळ्या शर्टाच्या माणसाने काय केलं आणि लाल शर्टाच्या माणसाने काय केलं. सो द डॉक्युमेंट विल बी प्रूव्ड इन दिस फॅशन. Whether there is any difficulty about proving of the document. In judgment of Sonu, in fact, why we are referring judgment, scheme of the act is itself. Admissibility of the document would be challenged on 2 points. Firstly, basically the document is not admissible, and secondly, the document is admissible, but it has been admitted by doing wrong procedure. For first objection, First objection can be taken at any point of time if the document is not admissible. But for second, document is admissible but only procedure is faulted with. That objection can be taken. That objection cannot be taken. So the procedure if lapse is there, because it is held by Honorable Apex Court even without appending the certificate. In fact, that law was earlier to the law of Arjun Khotkar, but in certain contingencies that law can be applied. This will be entirely procedure. And if any procedural lapse is found afterwards in appeal, then it would be incurable. So, basic thing is that after following all those technicalities, the electronic record can be get admitted in evidence. Again, there are certain presumptions. One presumption is there. Only I will read that presumption, 89A. Section 40, 88A. 88A, capital A, presumption as to electronic messages. The court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into the computer for transmission, but the court shall not make any presumption as to person by whom such message was sent. इथं असं म्हटलं त्यांनी की इलेक्ट्रॉनिक मेसेज जर तुम्हाला आला असेल, SMS म्हणा किंवा चॅटिंगमधले काही मेसेजेस असतील तर तो ओरिजिनेटर म्हणजे ज्यांनी पाठवला आहे त्याच्या IP ॲड्रेस जो इंटरनल प्रोटोकॉल त्याला ॲड्रेस दिलेला असतो त्या गॅजेटला, त्या गॅजेटवरून तुमच्या गॅजेट जे असेल त्या IP ॲड्रेसवर आला आहे हे प्रिझम्पशन आहे, रेग्युलरिटीचं प्रिझम्पशन आहे. मात्र याच्यामध्ये असं प्रिझम्पशन नाही की त्याच माणसाने पाठवलं आहे, कारण त्याचं गॅजेट कोणी वापरू शकेल अशी पॉसिबिलिटी आहे. तर हे एक मटेरियल मला त्यासाठी वाटलं ते मी तुम्हाला सांगितलं. इफ यू आर हॅव्हिंग एनी पॉईंट टू बी डिस्कस्ड ऑर एनी डिफिकल्टी, आय एम हिअर टू क्लॅरिफाय इट. बिकॉज ऑलरेडी इट इज 6:07. हां काय म्हणतो? नाही, you are satisfied, na? That is what. Okay, here I will conclude this subject. In fact, I was prepared with very from A to Z, but now I delivered lecture for some from D, from M, from Y, and I coupled all those things. So there would be some sort of distorted lecture would be there, but due to paucity of time, I have done that thing. It is always having honor and privilege to talk before lawyers, advocates, because I was erstwhile lawyer. I still has not forgotten that thing. Another thing for having honor to speak before you, that not because you are my colleague, you are I want to please you, but you are having very rich legacy. If we see our freedom struggle, then most of the leaders at every era of 10 to 15 years, ranging from Rajendra Prasad up to Lala Hardaya, take any name, Sardar Vallabhbhai Patel, Bal Gangadhar Tilak, and so on. They are from the legal fraternity. They were practicing lawyers. Thereafter, our father of nation, Mahatma Gandhi ji, was also the practicing advocate, who is called as father of nation. And Dr. Babasaheb Ambedkar, who is himself was a practicing advocate. He has prepared very good constitution for us. You are just noticing what is happening with neighboring countries, that their constitutions are falling. Still our constitution is raising towards the highly powered nation. So all those legal luminaries are there as your predecessor. You are carrying the legacy of them. It is always having proud and privilege for your profession. I think that you all are carrying that privilege on your shoulders, and it is always satisfying to talk with you, to interact with you, and lastly I will say thank you to all of you for listening me quietly and patiently. Thank you very much.
Sir, I have a question. Sir, जितकं मला समजलं तितकं अनलेस अँड अनटिल जोपर्यंत आपण 65B सर्टिफिकेट प्रोड्यूस करत नाही तोपर्यंत इलेक्ट्रॉनिक एव्हिडन्सची ॲडमिसिबिलिटी होत नाही. पण असं काही आहे का ट्रायलमध्ये की टाईम लिमिट, म्हणजे कोणत्या स्टेजला आपण 65B सर्टिफिकेट दाखल करू शकतो?
Yes.
म्हणजे ॲट एनी स्टेज
Yes.
पर्टिक्युलर काही?
Yes. In Khotkar's judgment, you may in fact read that judgment, Arjun Khotkar's judgment. So it is very best law on that. In that judgment, it is held that at any point of time, the said certificate can be given. In the appellate stage also, that certificate can be given. आणि त्यांनी असं म्हटलं त्याच्यामध्ये, in fact, it is the duty of advocate and judge also to get that certificate coupled with electronic record. असं म्हटलं त्यामुळे at any stage that certificate can be procured and given.
Yes, sir. Thank you.
Can I ask?
Yes.
सर,
Yeah.
आता आपण प्रोसिजर सांगितली सगळी. इथं बऱ्यापैकी डिफेन्स लॉयर सुद्धा म्हणून काम करणारे आहेत, म्हणजे आरोपीच्या बाजूने. मग काही अशा कोणत्या त्रुटी पकडायच्या, अशा कोणत्या त्रुटी पकडायच्या? आपण आता सरकार पक्षाला हाऊ टू प्रूव्ह सांगितलं.
नाही कंप्लेनंटला पण सांगितलं.
सर,
Now it is your skill being the defense advocate. I will not comment upon it.
जी सर.
Okay, thank you. ठीक.
Sir, I guess there is another question coming before us. So you can have your question.
Sir, which was the judgment of TV Nalawade, sir, regarding?
Seed. It is unreported judgment. I'll give it.
Okay.
It to you.
Yes. Okay.
By that way you will come into my court, na? असं पण येताना दिसत नाही कधी तुम्ही.
Yes.
Okay.
What is difference between admissibility and probative value?
So the good law on it is Sonu's law. Sonu judgment. You may just Google it. You will get your answer. Admissibility is different aspect. Okay, what is the difference in between proof and evidence? So that difference will answer his question. Evidence is genus and proof is species. Evidence would cover everything, but proof would the evidence only related to the matter. That is why 3 stages are given under Evidence Act. Section 1 to 67 of Indian Evidence Act are divided in 3 stages. Section 1 to 4 regarding interpretation clause and introductory clause. Section 5 to 55 about admissibility, about relevancy of evidence. Section 56 to 100, what evidence is to be given. And section 101 to section 167, in what manner the evidence is to be given. So, if we come to his question, what is the admissibility and what is the probative value? Admissibility, evidence, admissibility and probative value. These will be stages. Part of evidence given means everything is done. It is not like that. You have to give evidence. You have to show admissibility before the court. We'll take example of today's subject only. an electronic record is produced before the court. Electronic record is evidence. It is produced before the court. Now admissibility and probative value. Admissibility would be attracted by giving 65B4 certificate by proving content of that document, that electronic record. Two stages are completed, evidence and admissibility. Now probative. Probative value will be depend upon what is the exact facts in issue in that matter. If in that matter facts in issue is directly related with the evidence which is admissible before the court, then its probative value is proved as it is relevant evidence in that facts in issue. These are the stages.
Thank you, sir, for that highly insightful and enlightening lecture on electronic evidence. I now request Advocate Vyankat Bedre, sir, to present the vote of thanks.
Today's Honorable Speaker on the subject electronic records, how to be converted into evidence. Honorable District Judge Bhosleji, other dignitaries on the dais, and President of the Bar and office bearers, friends, I would like to extend my vote of thanks to the Speaker, who has very effortfully and explained the niceties of the law, and as to how in the era of technology, truthfulness of the document itself is to be considered. I just want to share you with my experience. Before 15 years ago, in election petition, the question arose whether at that time there was a cassette which was to be recorded via video, whether that forms are a part of a document or not. So firstly, we shall have to take into account one fact. The law frameworks were very wise. Before 200 years ago, they drafted the definition of document. You shall find the wording of the same. Any print mechanically produced and got. They were not knowing that the technology would get birth. We will be in the era of computer, mobile, quad, AI, so much and so forth. And therefore, to grant authenticity to such contents, the Indian Evidence Act and now to say Bharatiya Sakshi Adhiniyam came to be amended, over which we are very good enough. We got the Speaker who has update knowledge on the subject. We are very thankful to him. We are very grateful to hear you, sir. We are always trying to enlarge our legal acumen, because it is being said, law is an ocean. No one can be a master of law. But we found you seems to be master of your subject. We would like to extend by the bottom of the heart thanks to you. Welcome.
Thank you, sir. By taking the prior permission of the President, I hereby declare that the program and the sessions arranged today are hereby over and concluded. To every participant, I hereby declare that tomorrow we have scheduled 2 important lectures. by Advocate Amar Deshmukh sir on cyber crime, and our next speaker tomorrow would be Dr. Bhushan Kelkar sir, who would be expressing his thoughts on artificial intelligence and the future of law. Every one of you are deeply invited tomorrow to be a part of Conclave 2026 organized by Latur District Bar Association, Latur. Thank you.